Hi, I'm Michael Hughes, and this is Contract Mastery. Paragraph 6 of the lease agreement deals with late charges. As you recall, when we talked about the tenant's obligation to pay rent in paragraph 5, we said that the obligation to pay rent and the deadline for paying rent was a time is of the essence date. Well, if the tenant misses that payment deadline for the rent, the lease agreement gives us some provisions that talk about what happens then. And so we start here with paragraph 6A, and it says, if the landlord does not actually receive a rent payment in the full amount at the designated place of payment by the blank day of each month at 11:59 p.m., then the tenant will pay a late fee. And then we talk about how to calculate the late fee. So here in 6A, this number that we write in for the negotiated number of days, this is the grace period. So let's assume that the rent is due on the first of the month. How many days after the first of the month will the landlord give the tenant as a grace period? And it could be 2, 3, 4, however many days that the landlord wants to give the tenant as a grace period. And that's the number that you write in there. We'll talk a little bit about what that number should be here in just a minute when we get down to the boldface section here. But first, let's talk about how we're going to calculate the late fee that the tenant is going to have to pay. So, if the landlord does not actually receive the full rent payment at the designated place by whatever day of the month, let's say it's the third day of each month at midnight, then there's going to be a late fee. So the first, we charge an initial late fee equal to, and then we check one box only. And it can either be a flat dollar amount that we write in, or it can be some percentage of 1 month's rent. That's the initial late fee. In addition to that, the landlord can charge additional late charges of a certain dollar amount per day after that until the late charges and the rent are paid in full. Additional late charges for any one payment may not exceed more than 30 days. Okay, so we've got a particular month. Let's say the rent was due on the 1st. We've got a 3-day grace period. 3 days comes and goes. At midnight plus 1 minute on the 4th day, the landlord is entitled to charge a late fee. So they will either charge in a flat dollar amount, if we've checked the box for a flat amount, or they can charge a certain percentage of 1 month's rent. That's the initial late fee. In addition to that, the landlord can charge an additional late fee of however many dollars per day after that until both the rent and the late charges are paid in full. Now, it's important to understand that this only goes for one rental cycle at a time. So let's say in the month that we're talking about, first of the month comes and goes, no rent payment. The 3-day grace period comes and goes, no rent payment. On day 4, landlord charges an initial late fee. And then on the next day, day 5, we start charging additional late charges. Those can continue on up to a 30-day period. After the 30-day period, we cannot add any more late charges on for that particular month. The late charges don't go away. They're still due and payable. We just can't keep adding on additional late charges for more than 30 days. Now let's look at this boldface notice. Section 92.019 of the Property Code prohibits assessing a late fee until the rent has remained unpaid for at least 2 full days after the date on which the rent is due. This is in boldface, so what I want you to take away from this is there has to be a minimum of a 2-day grace period in paragraph 6A up there. The rent has to remain unpaid for at least 2 full days after the date on which the rent is due. After that, then the landlord can charge a late fee. But it has to be unpaid for at least 2 days after the rent is due. So what this means practically for us is the minimum grace period that we can put in 6A should be 2 days. And then after the rent remains unpaid for those 2 days, on the beginning of day 3, then the landlord can charge the initial late fee. So minimum of 2, whatever the landlord wants us to write in there, 2, 3, 4 are the most common ones that I've seen. There are some limits as to what a landlord may charge for a late fee. These limits are set out in Property Code 92.019. That section requires a late fee to be quote unquote reasonable. And for purposes of the Property Code, a reasonable late fee is defined as one of these 2 numbers. So if we're dealing with a property with 4 or fewer dwelling units, so a 4-plex or less, then a reasonable late fee is not more than 12% of the periodic rental amount. Now, this would include the initial late fee plus all of the additional day late fees that we are charging. So once you total all those up, it cannot exceed 12% of 1 month's rent. If we go beyond that, then the late fee is not considered reasonable under the Property Code. On the other hand, if our property has 5 or more dwelling units, then a reasonable late fee is not more than 10% of the periodic rental amount. So it doesn't specifically say that in our lease agreement. This is something that landlords are just expected to know. But these rules are found in Property Code section 92.019. 6B says, for the purposes of paying rent and any late charges, the mailbox is not the agent for receipt for the landlord. The postmark date is not the day that the landlord receives the payment. And this is an important concept. The mailbox is not the agent for receipt of funds. Just because you mailed a rent payment in as a tenant, that is not the same thing as the landlord receiving the rent payment. And that is the important thing. When does the landlord actually receive the funds? That is when rent is delivered. It doesn't matter when the payment was mailed. All that matters is when did the landlord actually receive the funds. So the postmark is not the date of delivery. Merely putting it in the mailbox does not mean that the rent has been delivered. It has to actually end up in the landlord's hand. The parties agree in paragraph 6B that the late charges that they have agreed to up in 6A, they agree that the late charge is reasonable based on uncertain damages to the landlord related to the late payment of rent, including direct or indirect expenses, direct or indirect costs, or overhead associated with the collection of late payment. The landlord's acceptance of a late charge does not waive landlord's right to exercise remedies under paragraph 27. And in the lease agreement, paragraph 27 is the default paragraph. So even though the landlord has charged a late fee, and even though the tenant has paid the late fee, the landlord still has default remedies available to them under the lease agreement.